Thank you very much for joining us today. So we'll get right into it. Now, you were a pivotal member in the ACA Reform Committee, and you were quite instrumental in the management of the drafting process. Can you tell us more about how this process was in practice?
Well, firstly, thank you very much for this initiative and for inviting me to share my views. It's a pleasure to be here, and I'm really pleased to have been a part of this legislation. So to your question, the process was actually very collegiate. I was the youngest on that committee. So as you're probably aware, there was a larger committee that comprised all the arbitration stakeholders in Nigeria, primarily the arbitral institutions and the arbitral bodies in the country. So you had, for instance, Chartered Institute of Arbitrators, Lagos Court of Arbitration, LASIAC, and all the rest. Now, within this larger committee, we then had a drafting committee that was charged with revising or actually looking at the draft that the original committee came up with and seeing if we could update it to include some of the provisions in the, for instance, 2006 amendments to the Austral Model Law. And beyond that, to also cater to provisions that the original draft not missed, but because ours was later in time, so there were innovations we could include because of happenings in the world, etc. So in that drafting committee was Mrs. Fumi Roberts as the chair, Professor Paul Idonige as a member, Sheila Ojo as a member, and myself as a member. So you can imagine the intellect that was part of that committee. Now, regarding the management, how we were able to get the work done, like I said, it was very collegiate. Notwithstanding my age, I'm speaking of both my physical age and my age at the bar, it was a very respectful atmosphere. We were very open as to the way we wanted to achieve the task. So Mrs. Roberts was very clear in setting the agenda as to what we wanted to achieve. And I volunteered to sort of put that in writing. So what I did initially was to come up with the drafts clause by clause, share it with the larger committee. They would give feedback and we would refine as is necessary. Now, after we finished our work within that drafting committee, we didn't want it to seem as if, oh, this is just the ideas of 3 or 4 individuals. So it was then sent to the larger house. And we had, I think it was a 2-day retreat in Lagos where we actually discussed a lot of these provisions, a lot of the vision to see whether we've actually captured everything we envisaged to propel a very modern arbitration law in Nigeria. So it was a very enjoyable process. It was a difficult process in terms of the volume of work involved, but it was a very fulfilling process. And I'm, like I say, really pleased to have been a part of it.
All right, that's great. I remember Mrs. Roberts speaking about the retreat. All right, we'll move on to the next question. So what were some of the main challenges you faced during the drafting process, and how were they addressed or overcome?
Well, I wouldn't really say there were challenges in terms of logistics. Naturally, there was apprehension as to whether we would be able to, live up to the expectations of the arbitration community and ensure that this. Thank you. Ensure that the legislation it goes through the legislative process smoothly. I would say a lot of the challenges, if we can call them that, were external in the sense that they didn't come from within the committee. So, for instance, I recall that during the drafting process, we had a proposed National Arbitration Center bill. And I remember when this came up, and there was a lot of apprehension because we felt that if that bill was enacted, it would take us many steps back from what we were trying to do in promoting Nigeria as a favorable arbitral seat. So we had to go to the public hearing at the National Assembly, and we made our submissions, and thankfully the honourable members of the House agreed with us, and the bill ended up not being passed. The second, if I can call it a challenge, was when we went for the public hearing regarding, then it was the Arbitration and Conciliation Bill at this stage. So it was the bill to amend the Arbitration and Conciliation Act. So it was pretty much still the Arbitration and Conciliation Bill. And we went through the public hearing phase. And then we had to speak against those who were opposed to the bill. So that was another challenge. But again, we looked at it very proactively. What we did was, after that initial public hearing, we ensured that the dissenting voices, we brought them within the larger committee to reform the ACA. And we were able to harmonize our views.
Okay.
And we eventually came up with what is now the Arbitration and Mediation Act. So yes, there were challenges, nothing we couldn't surmount, and we always wanted to take a problem-solving approach to any of them we encountered.
So you said the National Arbitration Center. Can you just say more about that? I'm very curious about that.
Right. So there was a proposed bill to establish a National Arbitration Center, and that center would be responsible for regulating arbitrators. Now, the problem we saw with that is it then put the regulation of arbitrators to the state.
Yes, in Nigeria.
Yeah. So there, I mean, besides the conflict questions, you weren't sure as to what the requirements to register as an arbitrator would be. You weren't sure as to whether a foreigner, that is a non-Nigerian, could come and do an arbitration in Nigeria. Would you be jeopardizing the sanctity of the award if that arbitration center hadn't registered them? Mm-hmm. And so many things like that. So we felt it was counterproductive. We felt the arbitration process regulates itself, in that if an arbitrator behaves badly, or if counsel behaves badly, then it's very unlikely that that individual will be appointed again, either as arbitrator or retained as counsel. So we didn't see the necessity or the rationale for it, and thankfully the House agreed with us and stopped that dead in the water, thankfully.
Okay, yeah, that makes a lot of sense. I imagine that it could, in a way, sort of make Nigeria not an attractive seat for arbitration because of, like you recently highlighted, the sort of issues that may come up. So that's interesting to know. All right then. So we'll go to the next question. In your opinion, what makes Nigeria an attractive hub or seat for arbitration in Africa, particularly in relation to Africa-related disputes?
Okay. So here we have to be objective. You know, I mean, there are things I could say, nice sound bites says, oh yes, Nigeria is a wonderful seat, come and arbitrate here. But the question I always ask myself is, if you have a dispute with no connecting factor to Nigeria, so non-Nigerian parties, non-Nigerian contract, non-Nigerian just everything external, no connecting factors, will they choose to come to Nigeria to arbitrate? And more likely than not, the answer will be no. So I like to, let's rephrase that question. What do we need to do in addition to make Nigeria a more attractive seat? Now, we've done a few things right. So if you look at empirical data, it points to generally three things. The core of what you need to do is a modern arbitration law. You need a judiciary that consistently respects agreements to arbitrate, and you need consistent enforcement of arbitration awards. Now, the modern arbitration law, we've ticked that box. We have an Arbitration and Mediation Act that models the 2006 amendments of the Industrial Model Law, and beyond that creates unique solutions for the problems we encounter as Nigerian practitioners. So we have a very modern arbitration law. In terms of the decisions, and I recall, I was at an event where the question was asked as to what is the effectiveness of arbitration in Nigeria. And one of the participants said that, arbitration is very effective until you need to enforce, until it comes into contact with the judicial process. Now, if you actually look at the statistics of Nigerian decisions to either enforce arbitration awards or enforce arbitration agreements, it's very high. It's actually very high, relatively speaking. Now, the fact that Nigerian courts do not enforce awards is not necessarily a bad thing if you look at the reason. right? So you might have a very bad award that is, for instance, contrary to public policy, or that is, for one reason or the other, should not be enforced, for the good of the arbitration process. Because if you enforce a bad award, it will give the process a bad name. Now, decisions like those do not come into the public knowledge or the public domain. What comes into the public domain is the bad decisions. So the decisions, for instance, that are amplified to show that this jurisdiction is inconsistent. And what we need to do is to ensure that we are able to solve those ones. Now, the question is, how do we do that? And the question I asked when the AMA was enacted was, okay, that's great, but what next? And I think we need to now have a series of dialogues, roundtables, discussions, call it what you want, to now tackle these other elements. And I think a nice starting point is if you look at, for instance, the centenary principles from CIR that highlight what are the characteristics of a safe seat. So beyond those hard things like the arbitration law, a ready body of arbitration practitioners and lawyers. So for instance, can somebody easily get a visa to come in to say, we're going to do our proceedings, right? Do we have, aside from Lagos and Abuja, do we have excellent facilities in the other parts of the country? Do we have the infrastructure, the stable internet connections? Those are the things we now need to start talking about. But the big ticket items, I think, are the interface between arbitration and courts, to ensure that our courts are given consistently good decisions. And that builds the reputation of the seat. I think we will get there. It won't happen overnight. The AMA was enacted this year. So I think we are in the process of trying to get the other components right. The quicker the better, certainly. And there are very many good markers we can take to say that this is a safe seat. I would draw your attention, for instance, to the Delos Guide for arbitration cases, where they use like a traffic light system. So if you look at a lot of our indicators, a lot of them are green, but a few of them are amber. And those things put people off. So I think we've started well. We still have a ways to go. So the next part of this conversation has to be, what next? What do we need to do to get all our indicators green to show that we are actually a very safe and a very consistent seat?
All right, thank you. Just one follow-up question to that. What steps are currently being taken to engage the judiciary? Are you involved in any initiatives or any plans that the state or arbitral institutions have to engage the judiciary on their supportive role and how best to support the arbitration process?
Yeah, so when it comes to interaction with the judicial, we have to tread very carefully. We don't want it to seem as if we are lecturing the courts or lecturing the judges. That can be very off-putting and it can be very counterproductive. So I think we need to, for instance, create some sort of a dialogue where we address concerns and we are able to see maybe a comparative approach to see, for instance, how other jurisdictions handle specific provisions of their national legislation, because the key is, we have a lot of very good decisions. The key is consistency. We need those decisions to come one after the other, after the other, after the other. If one goes wrong, as it were, then it is amplified beyond all measure, and nobody remembers all the good ones. So how can we do this? There are several ways we can do it. We can designate, for instance, a specialist judge within that jurisdiction. So we can say, some states already do this. Lagos has a commercial division. Delta State, for instance, has designated arbitration judges. So any arbitration-related application will go to that judge, and that judge has the expertise to deal with it. So within that jurisdiction, you will get the consistency you need. Now, we need to replicate it nationwide, right? So that's one. Another thing we can consider is the National Judicial Institute has refresher courses every year, training courses for newly appointed judges, and court administrative staff as well. We can put it in that curriculum So it comes up annually in the refresher courses, in the courses for newly appointed judicial officers, to again bolster that message to say, when you get an arbitration-related application, this is what the provision means. We're not telling the judiciary how to decide, but this is the intent behind the provision. This is how other jurisdictions have dealt with it, and this is the information you should know when applications of this nature come before you. But it's also very critical to because you don't want to sort of push the message such that any arbitration-related application will be granted. There are going to be bad ones. So the key is to discern between what is a good application and what is an application that will actually harm Nigeria's reputation as an arbitral seat. You don't want those bad decisions to go off and be enforced, right? So I think it's a multifaceted approach. We certainly need to gather momentum within the arbitration community. We need to galvanize interest from the judiciary. We don't want to seem as if we are forcing it on the judiciary. It's something they need to accept. So it's going to take a lot of give and take, a lot of discussions, a lot of dialogue. In direct answer to your questions, there are initiatives that are in the plan. I've spoken with like-minded colleagues who would like to collaborate in ensuring that these initiatives are put into fruition. Individually within our firm as well, we are also trying to plan a series of events, the what next events, to see how we can tick all those other areas, all those other criteria that promote Nigeria as a arbitration-friendly seat, if we can call it that.
All right, thank you very much. Were there any judges in the committee?
Well, so there are judges, for instance, that are members of CIR, that are members of the Nigerian Institute of Chartered Arbitrators and other bodies. So to that extent, when those bodies engage their members, those judges would have seen the messages and would have had an opportunity to give feedback. But one would imagine, and I don't have the data to support this, but one would imagine that the proportion of judges that are members of those institutions are quite low, relatively speaking. So it's not enough to create that dent, So there has to be a very deliberate and a very thoughtful way of engaging, in a way that doesn't disparage, but in a way that collaborates for the greater good. And I think there are many ways we can approach it. There are many ways we can look at it. For instance, I'll give you an example. There was, I remember I spoke at I think it was the 2015 Nigerian Bar Association General Conference, where we were trying to make the business case for arbitration. And if you look at a seat like London, for instance, in that year, and granted we were going through a bit of difficulties in the international oil market at the time, but the English justice sector generated more in terms of a proportion of GDP than Nigerian oil did. That's because a lot of people want to go and either arbitrate or have an engagement with the English justice sector because they know that they will get a quality decision, and that jurisdiction has a very high reputation. So there is a business case for it, right? So if we bring out all the elements, bring out all the positives, bring out all the negatives as well, and address everything, put everything down on the table, I think that creates an atmosphere where we can get consensus and we can have constructive engagement.
All right. I agree as well. Thank you very much, Isaiah, for joining us today. Thank you very much.
Right. My pleasure. Thank you so much for the invitation.
Before, you had 3 layers of review that could last for 11 years. Today, you have 4 layers of review that would last for 2.5 years. The choice is yours.